Michigan versus Casey Michael McKenzie. It is file 21-20677-FC. We are here today regarding a probation violation. We are proceeding today by video conference. Ms. Harris, would you like to place your appearance on the record?
Yes, Judge. Good morning. Christy here on behalf of the defendant.
All right, and Mr. McKenzie, I think, has previously been arraigned on this bench warrant. How does he want to proceed today?
Judge, I spoke to Ms. Holly, who is Mr. McKenzie's probation officer, and essentially Mr. McKenzie's two options in this case are drug court or a recommendation to do prison time. I have sent in an application for him to be pre-screened for his eligibility into drug court. I've not heard back yet. He also has two pending cases in district court that are set for a real exam on the 21st. So I'm asking for an adjournment.
Okay. How long do you think you'll need for an adjournment?
I believe they were screening him this week, so I would say 30 days.
All right, let's go with April 19th then at 8:15.
And may I ask one question? About a bond.
Mr. McKenzie, I don't mind you asking a question. Ms. Hara may have an issue with that. Anything you say is on the record at this point, and if you accidentally were to say something that compromised your position, that could be used against you. Do you understand that?
Yeah. I just want to know if I got a bond or my case is dismissed downstairs, would it be possible if I could get a bond up here and bond out, or something lower than 1,500 cash?
So Mr. McKenzie, you're on it's a cash only bond here in circuit court.
All right. That's good then.
I mean, if he does bond out on the other cases and you want to try to get in beforehand to have a discussion about the bond issue, I'd be open to that.
Okay.
Thank you.
So we are adjourned to April 19th at 8:15.
Thank you.
All right. Mr. McKenzie, you can let the officer that's with you know that you're done in court for today.
All right, thank you.
Thank you.
Can you call for Mr. Robinson again?
Mitchell Robinson, please. Yes. Thank you. Bye.
Ms. Underwood, Mr. McMullen is not logged in.
I will try to reach them, Your Honor. I will try to reach them.
Okay. All right, thank you. All right, Mr. Robinson, I apologize. I didn't realize that Mr. Dagger Rongosian had logged out, so.
Would you like me to come back then?
Give me just a moment. Mr. Sneed, would you be able to text Mr. Dagger Rongosian and see if he can log back?
I'll do so now, Judge.
Thank you very much.
Your Honor,
Yes.
as to Mr. McMullen, I left a message on a voicemail. However, I'm curious, Your Honor, the last I have was that Mr. McMullen was in bench warrant status for not appearing for a sentencing in July. And so I'm kind of wondering how it found its way to the docket today.
I don't know, other than to tell you on February 13th, the court issued a notice setting an arraignment. I don't know if that was an error. I guess I had assumed someone contacted the court and he was going to come in on the bench warrant, so. It doesn't appear that that's going to be the case, so I will then just let the bench warrant stand and we will deal with that if and when he gets picked up on it.
Thank you, Your Honor.
Okay, thank you.
And what are we going to do on Mr. Caldwell, Your Honor?
I do not know of anything we can do other than set it for another pretrial date and send another writ to his facility.
Thank you, Your Honor.
So let's set that for May 3rd at 8:15.
Thank you, Your Honor.
Thank you, Judge.
Thank you.
Have a good day.
Thank you very much.
Can you tell him Judge O'Sullivan's office? Or can you Mr. You sure? Okay, we just haven't seen it this morning. Okay, thank you. All right, thank you. Bye. You know, it's about a piece of pencils, right?
Should I just come back, Judge?
Give me just a second, Mr. Robinson. Let me,
Yes, sir.
Mr. Sneed, did you happen to hear anything from Mr. Dagger-Magosi?
I did, Your Honor. He said he'd be back soon, and that was 4 or 5 minutes ago. 8 minutes ago.
All right, just hang on, Mr. Robinson, because I'm sure as soon as you leave, Mr. Dagger-Magosi will get logged in, and then we'll be chasing you back again. So,
All right, sounds good.
thanks. Okay, Mr. Glazier, Mr. Winans is here. He's getting his audio connected right now. Are you going to need a breakout session with him?
I didn't know I had Mr. Winans. He's not on my list.
Okay, well, he's on the docket.
All right. Yeah, I'll have to call. It wasn't put on my list. Hold on a second, Your Honor. Yeah, I'll need a breakout with him. That's fine.
Okay. Okay, Mr. Robinson, I do have another case I can do now that I have Mr. Glazier here. So if you could let them know that we'll have you
Okay.
back when we get Mr. Dagamondosian, I appreciate that. Thank you.
Yep, thank you.
And can you call for Hezekiah Hall?
There's, we're back.
Lincoln Judge of Sims office. Could we have Hezekiah Hall for the judge, please? Thank you. Bye.
All right, we are on the record in People of the State of Michigan versus Keenan Kenyon Winans, file number 21-20582-FH and 22-20826-FH. These are both set for pre-trials this morning. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Sneed for the people.
Isaac Sneed for the people.
John Glazier on behalf of Mr. Winans.
All right, and Mr. Glazier, where do we stand with these cases today?
I need to speak with Mr. Sneed. Evidently, there was some discussion with Dawn. I must not have been at the last hearing, and I need to speak with Mr. Sneed for a moment.
Give me one moment. I will place you in a breakout session. Mr. Hall, as soon as Mr. Glazier is finished working on this case, I will have him speak with you.
All right, thank you, Your Honor.
All right, we have Mr. Glazier and Mr. Sneed back from the breakout session. Mr. Winans, if you're there, I'll need you to get back in front of your camera so that we know you're present. Okay. All right, Mr. Glazier, where do we stand?
Yeah, Your Honor, Ms. Van Duzen and Phoebe worked out a deal on this last time. It just, I guess they didn't put it on the record. What my client is gonna do is plead to larceny 1,000 to 20,000, which is a 5-year felony, with the understanding that counts 1 and 2 would be dismissed and the absconding would be dismissed. There would be a killabrew to Haida with no upfront jail, and he is to make some sort of restitution, payment on the restitution, but pay restitution over the term of probation. I think he's
All
gonna
right,
have at
Miss-
least 1,000 up front on the restitution when it comes time for sentencing, something like that.
All right, Mr. Sneed, is that a complete and accurate statement of the plea agreement?
Yes, it is, Your Honor.
All right, so I'm gonna need an amended information on that, so we'll pass this for now till I get the amended information. So Mr. Winans, I'm gonna place you back in the waiting room until we have the amended information we need, and then we'll proceed.
Okay.
Okay, Mr. Glazer, do you need to speak with Mr. Hall?
Yes.
All right.
Your Honor, may I address the court?
Yeah,
I do see in our file an amended information on Winans that Ms. Mears signed back on January 26th, adding that count for larceny.
okay.
I'm wondering if that's in the court file.
I'm sorry, what was the date?
She signed it January 26th, proof of service, January 25th.
I do not have
Okay.
that in the paper file. Let me check
Okay.
the computer just to make sure. No, it doesn't look like that was filed.
Would you like me to email it to you, Judge? Or-
Yeah, if you could email that over, I will, we'll print it out. Okay, Mr. Glazer, are you ready to proceed with Mr. Hall?
Could I speak with Isaac on this one too as well, Your Honor?
Yeah, give me 1 second. All right, Mr. Glazer, are we ready to proceed?
Your Honor, I was gonna ask to put this off, but if I could talk to my client again, I may be able to resolve this today.
All right, 1 second. Okay, Mr. Glazer, where do we stand?
I believe Mr. Hall is gonna enter a plea, Your Honor, and try to take care of all these files.
All right, so what is the agreement?
If I could interject here, Judge, I think it'd be best, since there's multiple files, if I could email you the document.
Sure, that'd be fine.
Okay, I just sent it. Okay, do we have an amended information, Mr. Sneed, or is that something you need to prepare? Your Honor, we are preparing the amended and file ending 4-1 FH right now.
Isaac, on file 1070, the retail fraud is there a supplement on that habitual?
If there is, it's being dismissed.
Okay.
Let's go back to Mr. Winans then while we are waiting for that amended information. All right, we have Mr. Winans back now, so we are on the record in People versus Keenan Kenny Winans, file 21-20582-FH and 22-20826-FH. I do now have the amended information. And so I'm clear that I remember accurately, Mr. Wyman is pleading to count 3 on the amended information in the file ending 582 and file ending 826 is dismissed, being dismissed.
That's correct. Yeah.
That's correct, Judge.
Okay, thank you. Mr. Winans, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury.
Yes,
And you are Keenan Kenyon Winans, correct?
yes,
Mr. Winans, is your intention to plead guilty to count 3 on the amended information, larceny of $1,000 or more, but less than $20,000?
yes,
You understand the maximum penalty for that offense is up to 5 years in prison and or a fine of $10,000 or 3 times the value of the property taken, whichever is greater.
yes,
Are you satisfied with Mr. Glazer and the advice that he's given you?
yes.
I apologize. Mr. Glazer has apparently dropped out of the meeting. We will wait a moment to see if he gets logged back in.
Your Honor, I texted Mr. Glazer, but I have not heard back yet.
Great, thank you, Mr. Sneed.
Judge, Mr.
Yes.
Glazer is having trouble with his connection at his house, so he's on his way to his office.
Okay. All right, Mr. Hall, can you tell the officer that's with you there that it's going to be a few minutes, so we would like to see Mr. Robinson? if
Yes, sir.
possible.
Yes, sir.
Hey, it's gonna be because my lawyer is just doing something, I guess. We said, can the judge said, can you see Mr. Robbins?
Yeah, you going back there, or you just gonna wait? You don't have another room.
Here, I don't know. Here, let me see. Hey, Your Honor,
Yes, yes.
would you like me to go back until Glacier's here? Like go back to the block and then have Mr. Robbins come here? Or do you want me to wait
Yes,
here?
yes.
All right. Yeah, please.
Okay. Yeah, got you. Oh, yeah. Oh, that. Hey, now. Is that the last one? Oh, excellent.
Yeah, I have to look to the.
Hello, it's Karen, the judge. Could we have Mitchell Robinson into the judge, please? All right, thank you. Bye.
All right, Mr. Dagger Rogosian, we have Mr. Robinson back. Are you ready to proceed?
Yes, Your Honor.
All right, we are back on the record in file 23-21226-FH, 23-21227-FH, and 23-21285-FH. People versus Mitchell Lee Robinson. I do now have the amended information. In file ending 227. Mr. Robinson, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury.
Yes.
And you are Mitchell Lee Robinson?
Yes, sir.
Mr. Robinson, you've heard the statements of your attorney and the prosecuting attorney. Is it your intention to plead no contest today in file 23-21226-FH to domestic violence?
Yes, sir.
Is it also your intention to plead, I'm sorry, in the 227 file, is that a guilty plea or a no contest plea, Mr. Dagger?
Your Honor, all of these are no contest for civil liability. There's a pending divorce, and so for that purpose, these would be no contest.
All right. Is it also your intention, Mr. Robinson, to plead no contest in file 23-21227-FH to aggravated assault?
Yes, sir.
Is it also your intention to plead guilty in file, I'm sorry, no contest in file 23-21825-FH to tampering with an electronic monitoring device?
Yes, sir.
Do you understand the maximum penalty for the domestic violence charge is up to 93 days in jail and or a $500 fine?
Yes, sir.
Do you understand that the maximum penalty for the aggravated assault charge is 1 year in jail and or a $1,000 fine?
Yes, sir.
Do you understand that the maximum penalty for the tampering with an electronic monitoring device charge is up to 2 years in prison and or a $4,000 fine?
Yes, sir.
Are you satisfied with Mr. Dagger Margosian and the advice that he's given you?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that other than as we've discussed on the record here today? Is that correct, Mr. Sneed?
Yes, it is, Your Honor.
Yes. Mr. Dagger Margosian?
It's correct. I just want it to be acknowledged that the 2 misdemeanor assaultive files will be under 769.4A. We had discussed that previously.
Correct, yeah.
Yeah.
Yeah, you had said that on the record earlier, earlier this morning, so we're, okay, Mr. Robinson, if a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You can ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have the witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Robinson, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, sir.
You also understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right.
Yes, sir.
If you are not a citizen of the United States of America, a conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
Yes, sir.
I'm sorry, do you have any questions about any?
Oh,
of those
no.
rights?
Oh, no, sir. Sorry.
How do you wish to plead then? Or do you understand you're giving those rights up?
Yes.
How do you wish to plead then in file 23-21226-FH to that on or about November 29, 2022 in Woodstock Township, Lenawee County, Michigan, that you did commit the offense of domestic violence? I'm sorry, if you responded, Mr. Robinson, I didn't hear you.
Sorry. Mr. Dagan, we're going to it.
Yeah, no contest.
Okay.
Okay, so I need you to say that, Mr. Robinson.
No contest.
Okay. And how do you wish to plead in file 23-21227-FH that on or about December 31st, 2022 in Woodstock Township, Lenawee County, Michigan, that you did commit the offense of aggravated assault?
No contest.
And how do you wish to plead to in file 23-21285-FH that on or about February 10, 2023 in Woodstock Township, Lenawee County, Michigan, that you did commit the offense of tampering with an electronic monitoring device?
No contest.
Has anyone made any threats or promises to induce you to plead no contest to those charges?
No, sir.
You understand that if I accept your pleas, you will be giving up any and all claims that those pleas were given as a result of threats or promises that were not disclosed to court on the record here this morning, or that it was not your own choice to enter those pleas?
Yes, sir.
Is prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Robinson to plead guilty?
No, Your Honor.
None, Your Honor.
Mr. Robinson, other than as we've discussed on the record here today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, sir.
Is it your own choice to plead no contest today?
Yes, sir.
All right, Mr. Sneed, Mr. Dagan, how are we establishing the factual basis?
Your Honor, I can, based on stipulations in using the police reports in these three files, I'm happy to put the facts on record.
All right, if you'd like to do that now, you can proceed.
All right. Your Honor, first I guess we can start with 226. Let me just make sure I have the right report. This is report from Lenawee County Sheriff. The report number being 220012458-001. This is date of 11/29/2020 in Lenawee County, state of Michigan. Jessica Fenton, who is the victim in this matter, states that she was hit in the face with an open hand or backhand by Mr. Robinson, as well as punched in her arm, as also that Mr. Robinson grabbed her chin and squeezed. Those would be obviously without consent. So I believe that that would satisfy the domestic violence charge on 226.
All right, Mr. Sneed, are the people satisfied that that satisfies the factual basis?
I would just add that Jessica Fenton is Mr. Robinson's wife, and it occurred in 2022 rather than 2020.
22, right.
So yes, people are satisfied with that additional information, Judge.
And Mr. Dagger-Margosian, I presume you agree to that additional information?
I do.
Okay.
Shall I move on, Your Honor?
Yes, you can proceed.
On case ending in 227, we'll be stipulating to a Lenawee County Sheriff Police Report number 220013770. Report was taken 12/31 of 22 in Lenawee County, state of Michigan. We'll be using a grader to satisfy the lesser. Miss Fenton, same victim from the prior case, stated that she was hit in her face and was choked by Mr. Robinson. I don't believe that there needs to be a domestic relationship established, but it is the same person, and they were married at the time. Obviously, this was without her consent.
People are satisfied.
Okay, thank you.
And then lastly, Your Honor, for case ending in 285, we'll be stipulating to a police report from Michigan State Police, report number 014-0000611-23. Report taken February 11th, 23. Mr. Robinson, this is in Lenawee County, state of Michigan. Mr. Robinson had a bond condition to have a GPS tether affixed to his ankle. Mr. Robinson took that tethered device off without any legal permission to do so. And I think that probably satisfies the elements of that.
Mr. Sneed?
People are satisfied, Judge. Thank you.
Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, thank you, Your Honor.
Yes, Your Honor.
Okay. I will accept the plea then, or the pleas. They have been given understandably, voluntarily, and accurately. Mr. Robinson has had full knowledge of his rights. He's had competent counsel. Court's not made any agreement regarding the possibility of plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone of them, other than as we discussed on the record here this morning. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for April 20th at 8:15 a.m. Mr. Robinson, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Yes, sir.
Mr. Dagger-Margosian, we also had contempts for violation of bond conditions in the 226 and 227 files. Does Mr. Robinson wish to resolve those today?
Well, I guess, Your Honor, I mean, because the plea is what he pled to essentially admits to that and takes that into account. I mean, I'm wondering if the court would dismiss those, or in the alternative, if he were to enter a plea, grant him credit for time served. He's been in custody for about
2 months.
a month, or he says 2 months on those.
Well, I've got a month time served and I've got a month now.
Yeah. So, I mean, we're happy to take care of those, but like I said, the facts of the plea essentially took care of those or accounted for those.
I understand that, but he's alleged that he's violated his bond conditions. That's a separate contempt of court than the felony charge that he pled to. So
what I'm asking, I'm sorry.
If he wants to plead to it, he can plead to it, or if he wants to set it for a trial, set it for a trial.
Well, I mean, I guess what I'm asking for is the court to consider the length of time as well as the admission of what he just handled.
I'm not in the habit of telling people what the sentence is going to be before they resolve the issue. So he can plead to it, or we can set it for a trial.
Well, again, as the conduct in the bond violations, he entered pleas to those. So I mean, he can enter, Mr. Robinson, it would probably be advisable to enter the pleas to the bond violation, understanding that, we'll be asking the court to take into account the conduct that occurred and the time that you've spent in custody. Would you wish to do that, Mr. Robinson?
Yes, yes, sir.
Right, Mr. Robinson, you understand that as with the underlying cases with respect to the bond violation, you would have a right to contest that contempt of court charge and have a trial on that.
Yes, sir.
You understand that throughout that trial, again, you'd be presumed innocent until your guilt is proven beyond a reasonable doubt.
Yes, sir.
Again, you'd have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. And you also have the right to have any order any witnesses that you have for your defense to appear at that trial. Do you understand that?
Yes, sir.
Again, you're not required to testify at your trial, and no one can say anything about you not testifying. You'd also have the right to testify at your trial if you wanted to testify. Do you understand that as well?
Yes, sir.
Has anything been promised to you in order to get you to plead guilty to the contempt of court?
No. No, sir.
Have you been threatened in any way in order to get you to plead guilty to the contempt of court?
No, sir.
If I accept the plea, you're going to be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record here this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty today?
Yes, sir.
How do you plead then to the charge that you violated the terms of your bond conditions? Robinson, how do you plead to the charge that you violated your bond conditions?
Guilty.
So in files ending 226 and 227, you were released on a bond that had a condition that you wear a GPS tether. Is that correct?
Correct.
And at some point you cut off or you removed your GPS tether. Is that right?
Did not cut off. Yes, but it was taken off.
In some way you removed it from your person.
Yes, sir.
The bond conditions also prohibited you from being at Jessica Fenton's house. Is that correct?
That is my house, but yeah.
And after taking off the GPS tether, is it correct that you went into that house and made video recordings?
That is correct, because she let me in the house.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Robinson has had full knowledge of his rights to have competent counsel. Mr. Dagger-Margosi, do you want me to sentence today, or do you want to wait until the sentencing on the underlying cases?
Your Honor, I'd ask for an immediate sentence today. I believe that would be appropriate. And
All right, is there anything you want to say on behalf of Mr. Robinson before the court passes sentence then?
Yes, Your Honor. Number one, as indicated earlier, Mr. Robinson and Ms. Fenton they're initiating a divorce. This will finalize any sort of, relationship that they have. Additionally, in speaking with or getting information from Mr. Robinson's family, Ms. Fenton has vacated that listed address. So I'm sure in the divorce proceedings, there will be a request for, once Mr. Robinson is released, for him to be able to return to the home that he owns, as he just indicated. Furthermore, Mr. Robinson has been in custody for a substantial amount of time, between 1 or 2 months. I mean, he indicates that it's been about 2 months. Obviously, on a bond violation, the max would be 93 days. In reality, that would be 78 days with Sheriff Good time. So with his sentencing coming up in about a little over a month, the amount of time that he's already done, the factors that I just indicated, I think it would be appropriate to, and he won't be getting out until sentencing. So what I would be asking for is the court to just, I think it's appropriate for a credit for time served sentence on these bond violations, and then we will be handling the sentencing on the underlying offenses.
Well, the violation, the contempt occurred on February 7th, right?
Judge, that's when we had the initial tamper. That's when I received notification that there's nothing wrong with the device.
He was arrested on the warrant for the violation on February 13th.
So I mean, at the minimum, Judge, he's been in jail for a month on these.
So he's got 30 days that since he was arrested on violation. All right, Mr. Robinson, is there anything you want to say on your own behalf before the court passes sentence?
No, sir.
All right, it is the sentence of the court that you serve 60 days in the Lenawee County Jail. I will give you credit for the 30 days that you have served since you were arrested on the warrant. All right, so we will see. I'm sorry.
That's on both of the violations?
Yeah, that's on each of the files.
Thank you.
All right, so again, Mr. Robinson, someone will be in touch with you from the probation department for your pre-sentence investigation, and we will see you back for sentencing on April 20th.
All right.
Mr. Murphy, have you heard anything about Mr. Moore yet?
Your Honor, I've had no answer. I don't know if Ms. Andrews got it, if they emailed her at all. I know they called last time, your office as well as trying to contact us, but I've had nothing so far.
So this is what happened last time back on February 22nd. Mr. Moore was not here, even 48-hour grace period, and then apparently we got contacted and we set the pre-trial for today. You have confirmation, Mr. Murphy, that he's at a treatment facility?
Yes, Your Honor, I'd emailed that to Ms. Andrews. She had talked to them last time as well. I thought I have an email from her this morning saying that she spoke with a Chase on February 22nd in regards to this date, saying that it'll be set up. Again, Mr. Moore, he's in let me see, your Northwest Community Corrections Facility in Ohio. It's, from my understanding, I mean, it is a facility from the Department of Corrections, but it is a rehab facility he was ordered to go to. So he has no control over it. It's purely through his case manager, which is who we tried to connect with, and we're waiting for a message back from.
If I could interject, our prosecutor's notes indicate he was released from CCNO on January 5th, 2023. The facility notified our office, not the defendant. So that's our note from January 5th and February 21st. So that's our last information.
And again, that was brought up on the record last time. I don't know where that's coming from. That's why I mentioned, Miss Smith's name. She's the one who I talked to. And again, I thought she talked to Miss Andrews, he's there. He's at that rehab facility, the information I forwarded to the court. I mean, he was at a reception facility in Toledo, Ohio at first before he got transferred to there. So it's a different facility than he started out with when he was originally taken in custody down in Ohio. But again, he's at this. I mean, I'd also forwarded the email to.
Well, at this point, Mr. Murphy, what I'm gonna do is adjourn this, and I'm gonna need something more than an email or a phone call that I can't continue to just not have him show up and take someone on the other end of the phone saying that, oh, he's here. This is the second or third time he's not appeared. And so I need some kind of hard documentation that he is where you say he is.
Yes, Your Honor.
We were not on the record yet, so can you start the record? We are on the record in file 22-21147-FH, People of State of Michigan versus Kelly Dean Moore. This is the date set for a pretrial conference this morning. It was set for 8:15 this morning. It's now 10:45. Mr. Moore is not present. I have had a discussion off the record with the attorneys in this case. First, let me ask them to place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Matthew Murphy, appearing on behalf of Mr. Moore.
All right. So again, Mr. Moore is not present here today. We have had discussions at the previous hearing about his location. Mr. Moore did not appear at the previous trial conference, and the court indicated at that pretrial conference that the court would issue a bench warrant for his arrest unless we were contacted within 48 hours. We were apparently contacted in some way within that 48-hour grace period by someone who indicated that Mr. Moore was at a treatment facility in Northwest Ohio. There is some conflicting information from January 5th that had indicated that he had been released from that facility. So I have advised the attorneys that I will adjourn this one more time and require some kind of confirmation more than a phone call or email that Mr. Moore is in fact located at this facility. If he doesn't appear at the next pretrial, and I don't have that, I'm going to issue a bench warrant for him, because I simply, at this point, I'm not sure where he is, and he does not appear for his hearings. Let me. While I have been speaking, a few people I don't recognize have popped into the waiting room. Let me see if perhaps this would be Mr. Moore.
This is Conrad. I'm sorry.
All right. I apologize, Mr. Vincent. Just making sure you weren't someone else. I'm going to put you back in the waiting room for
No
just a
problem.
moment.
Thank you, Your Honor.
All right. So everyone else I do identify. So I'm going to adjourn this to April 26th. At 8:15 a.m.
Yes, Your Honor, I'll get that information. I'll get the documentation to your office as soon as I can reach them. Thank you.
All right, thank you.
Your Honor, do you want my office to do a stipulation in order for that new date?
No, court will issue a notice.
All right, thank you, Your Honor. You have a good morning.
Thank you. Mr. Glazer, you ready to proceed with Mr. Hall?
Yes, I am, yeah.
All right, we are on the record in the People versus Hezekiah Hall, file 22-21070-FH, 22-21141-FH, and 23-21292-FH. These are we had been on the record previously with respect to these cases. It is my understanding at this point that Mr. Hall is going to plead guilty in file 22-21070-FH as charged count 1, retail fraud first degree. In file 22.
You're on that one, on that file, the habitual offender would be dismissed.
All right, so yeah, all according to the agreement that I have, all habitual offenders or supplements will be dismissed.
Okay. I just wanted to make sure.
Okay. So file 22-21141-FH, Mr. Hall has agreed to plead guilty to count 4, retail fraud second degree, and count 5 on the amended information, attempted possession of methamphetamine. There is in the agreement some additional information with respect to district court files. I leave it to Mr. Steve and Mr. Glazer. If you want to review that on the record here, you can, but I don't believe it's necessary for my purposes.
No, I don't need to, Your Honor. Did you cover the other file? I didn't hear 292FH.
If I could specify, Your Honor, in paragraph 1A of the plea agreement, it references District Court File 23044FY. That's been bound over and is now Circuit Court File 23021-292FH. At the time the plea agreement was written, we didn't have the Circuit Court number yet, so that's why it's a fill in the blank.
Okay, I apologize. I missed that. So file. Okay, that's the 23-21292 file now.
Correct. That's page 2 of the docket, second entry down.
Okay, so with respect to that file, Mr. Hall be pleading to Count 1, possession of methamphetamine, and count 2, carrying a concealed weapon, again, the habitual supplement being dismissed. Is that all accurate?
Yes, Your Honor. Thank you.
Mr. Glazer?
Yeah, that's correct. Just again, with no sub.
Yeah. Okay, Mr. Hall, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
You are Hezekiah William Hall.
Yes, Your Honor.
Mr. Hall, you've heard the statement of your attorney, and the prosecuting attorney is it your intention to plead guilty today in file number 23-21292-FH to count 1, possession of methamphetamine or ecstasy.
Yes, Your Honor.
You understand the maximum penalty for that offense is up to 10 years in prison and or a $15,000 fine.
Yes, Your Honor.
Is it also your intention to plead guilty today to count 2, carrying a concealed weapon?
Yes, Your Honor.
You understand that the maximum penalty for that offense is up to 5 years in prison and or a $2,500 fine.
Yes, Your Honor.
Is it your intention to plead in file number 22-21070-FH to count 1, first-degree retail fraud?
Yes, Your Honor.
Do you understand the maximum penalty for that offense is up to 5 years in prison and or a $10,000 fine or 3 times the value of the property, whichever is greater?
Yes, Your Honor.
And is it your intention to plead in file number 22-21141-FH to plead guilty to count 4, retail fraud, second degree?
Yes, Your Honor.
And you understand the maximum penalty for that offense is up to 1 year in jail and or a $2,000 fine or 3 times the value of the property that was taken, whichever is greater?
Yes, Your Honor.
And is it also your intention to plead in that file to count 5 on the amended information, attempted possession of methamphetamine?
Yes, Your Honor.
I apologize. No, my paper shuffling. I misplaced the amended information. That's a 5-year.
Yes, it is, Judge.
You understand, Mr. Hall, that the maximum penalty for that offense is up to 5 years in prison?
Yes, Your Honor.
Are you satisfied with Mr. Glazer and the advice that he's given you? Mr. Hall, are you satisfied with Mr. Glazer and the advice that he's given you?
Yeah, I'm sorry, Your Honor. Yes.
That's okay. Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
Yes, it is, Your Honor.
That's correct, Your Honor.
Is that also your understanding, Mr. Hall?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have the witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Hall, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you understand all of those rights?
Yes, Your Honor.
Do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead then in file 23-21292-FH, that on or about January 25th, 2023, in the city of Adrian, county of Lenawee, that you did commit the offense of possession of methamphetamine?
Yes, Your Honor.
If you'd like to plead guilty, you would need to say guilty.
Yes, Your Honor. I plead guilty.
All right. How do you plead to the charge that on or about January 25th, 2023, in the city of Adrian, county of Lenawee, that you did commit the offense of carrying a concealed weapon?
Yes, Your Honor, I plead guilty.
In file 22-21070-FH, how do you plead to the charge that on or about September 9, 2022, in Madison Township, Lenawee County, Michigan, that you did commit the offense of retail fraud first degree?
That what?
That you did commit the offense of retail fraud first
Yes.
degree?
I plead guilty.
All right, and in file 23 no, I already asked you about that one. File 22-21141-FH, how do you plead to the charge that on or about November 7, 2022, in the city of Adrian, county of Lenawee, that you did commit the offense of retail fraud second degree?
Yes, I plead guilty.
And in that same file, how do you plead the charge that on or about November 7, 2022, in the city of Adrian, county of Lenawee, that you did commit the offense of attempted possession of methamphetamine?
Yes, I plead guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
That I get like a year or 23 months, up to 23 months in prison.
All right, so someone has promised you that?
Well, someone has told me that.
Your
That's
Honor, I advised him this morning that I did the guidelines on these charges. And one of them is 0 to 17, or it could be read another way as being 5 to 23. I can't guarantee those calculations. I've done PS or sentence guidelines many times, so and I believe that's where he'll guideline out at is either 0 to 17 or 5 to 23 months.
Okay. Do you understand, Mr. Hall, that ultimately it's my job to score the guidelines, and it's possible that I could score them differently than what Mr. Glazer has told you he scored them at?
Okay, yes, Your Honor.
Okay, do you understand that that could result in a sentence that is different than what he talked to you about?
Yes, Your Honor, I'm sorry.
Okay, I just want to make sure it's fine. I just want to make sure you understand the situation before I accept your plea. Other than that discussion that you just told me about, has anyone made any other threats or promises to you to induce you to plead guilty to these charges?
No, Your Honor.
Do you understand that if I accept your pleas, you will be giving up any and all claims that your pleas are given as a result of threats or promises that were not disclosed to the court on the record here this morning, or that it was not your own choice to enter those pleas?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Hall to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Hall, is it your own choice to plead guilty?
Yes, Your Honor.
All right, Mr. Glazer, do you want to cover the factual basis?
Yes, Your Honor. Mr. Hall, On or about January 25th of 2023, did you come into contact with the police?
Yes, Your Honor.
I'm not your honor, just, you can just say yes, sir.
Or yes, sir, my bad, I'm sorry.
All right. And as to count one in this, it says that at the time you were in possession of some methamphetamine, is that correct?
Yes, sir.
How much did you have on you? Do you remember on that occasion?
No.
All right, but it was on your person, and you did know it was methamphetamine.
Yes, sir.
And you also had a knife that was concealed on your person when they arrested you, is that correct?
Yes, sir.
And that all occurred here in Lenawee County, the state of Michigan?
Yes, sir.
All right, as to the next file, it indicates that on or about September 9th of 2022, you were at Walmart, is that correct?
Yes, sir.
That was here in, that was I think in Madison Township in Lenawee County, is that correct?
Yes, sir.
And on that time, did you try to exchange and get a refund for some property that belonged to the store that you really had never purchased it? Is that true?
Yes, sir.
What kind of property was it?
I have no idea.
Okay, whatever it was, though, you would agree that it was worth more than $1,000. Is that true?
I'm guessing so.
Well, you can't guess, so you're pleading guilty. You got.
Yes, sir. Yes, sir. Yes, sir. I just can't remember. Yes, sir.
All right, but it was over $1,000 worth of property. Is that
Yes,
correct?
sir. Yes, sir.
All right. And then on November 7th of 2022, were you here in Lenawee County in the state of Michigan?
Yes, sir.
And on that date, were you at Myers?
Yes, sir.
And on that occasion, you attempted to alter, transfer, remove, or replace, conceal the price of property which was offered for sale with intent to not pay for the property. Is that correct?
Yes, sir.
And the difference in price would benefit you between $200 but less than $1,000. Is that true?
Yes, sir.
All right. And when you got arrested on that date, you had some methamphetamine on you as well?
Yes, sir.
And you remember how much you had?
No, sir.
But you knew it was methamphetamine and it turned out to be methamphetamine. Is that correct?
Yes, sir.
I don't have any other questions, Your Honor.
Mr. Sneed?
People are satisfied, Judge.
All right, has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, it has.
Mr. Glazier?
Yes, Your Honor.
All right, I will accept the pleas then. They've been given understandably, voluntarily, and accurately. Mr. Hall's had full knowledge of his rights. He's had competent counsel. Of course, not made any agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department and set sentencing for April 27th at 8:15 a.m.
Really?
Mr. Hall, someone will be in touch with you from the probation department to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Yes, sir. Yes, Your Honor.
All right, bond will be continued as currently set then, and we will see you back for sentencing on April 20, what did I say, 7th? April 27th.
All right, thank you, Your Honor.
Thank you.
That be all for today?
Yes, that's all.
All right, thank you, Your Honor.
Are you muted, John?
What's that?
Are you muted?
I'm doing one more right now.
I'll come back.
All right, Mr. Murphy, we're calling for Mr. Parker now. Mr. Malero, you're here on the PPO violation.
Yes.
Stephanie Rice, Your Honor.
Okay, so Ms. Rice is not here in the courtroom and she's not logged into the Zoom session. You know where she is?
I do not know where she is, and I have not sent her a telephone message and a text message, so.
I am at the mercy of the court.
And Your Honor, Judge Anzalone did just issue a bench warrant on her criminal cases this morning for her non-appearance without waiting the 48 hours.
Okay, let me call those cases then. All right, we are on the record in Gina Louise McVetta versus Stephanie Rice, file 21-48469-PH. And Thomas James Martolak versus Stephanie Lynn Rice, file number 21-48169-PP. These are both set for hearings on personal protection order violations. This morning, we're proceeding today by video conference. The courtroom is open to the public. I have advised first let me ask the attorneys to place their appearance on the record, beginning with Ms. Muir.
E.B. Mayor, on behalf of the people.
Salvatore Malero on behalf of Stephanie Rice.
Okay, I have advised the attorneys off the record that Ms. Rice is not logged into the Zoom session and is not present in the courtroom. The court's had a Zoom session running since 8 o'clock this morning. I've been monitoring the Zoom waiting room the entire time. Ms. Rice has not appeared there at any time. This matter was set for, these two matters were set for hearing this morning at 10 a.m. It is now 11:08 a.m. And Ms. Rice has not appeared. Mr. Malero, is there anything that you would like to state for the record?
Yes, for the record, Your Honor, I have left a telephone message on the number we have listed and sent a text message to that number as well. I have not received a response as of this moment. And those messages were sent out about 10:15 this morning.
Ms. Muir, anything you would like to state for the record?
Ms. Rice also had her criminal cases up before Judge Anzalone today for a final pretrial, with her jury trial being set April 4th, and she failed to appear in front of Judge Anzalone as well. And Judge Anzalone did issue a bench warrant without waiting the 48 hours. So that's what I would be asking for on these cases.
All right, I do find Ms. Rice has failed to appear. I am going to issue a bench warrant for her arrest and set bond on bench warrant in the amount of $10,000 cash or surety in each file.
Thank you, Your Honor.
Thank you.
Have a nice day.
Okay, thank you, you too. We have Mr. Parker here, but we don't have Mr. Murphy. Good morning again, Mr. Vincent. I had Mr. Raines in my waiting room earlier, but he's not there now. Have you had any communication with him?
I have not. I believe that we filed a counter complaint in this case, and I'd be willing to put the proofs on with my client.
All right, give me just a moment. We'll try to contact Mr. Raines' office and see. I presume he wants to be here for this, so.
No problem. Either way. Thank you, Your Honor.
Okay.
All right, thank you. Bye.
What if you're close to the phone on me? Now, man. This motherfucker is probably figured out like, damn, what are you supposed to do? Yeah, we are. Back to city. Well, I have $12,000 cash only, like, there's no way, I'm not gonna get you in. So, like, are you serious? Like, yeah, we're gonna play with you. All right, man, I take my shit, go out and like, yeah, I guess to leave him. I was like, all right, man, blah, blah, blah. And he's like, well, you need to get your fingerprint on this black, it's gonna be like, in person, because, you know. Walk to the fucking computer, and I just look at the computer, and I'm like, it's not even me, bro, you fucking think me, like, yeah, you fucking, I go, all my shit away, all the way down.
Mr. Parker, I'm going to place you back in the waiting room until we have your attorney here.
Yes, sir.
Oh, okay.